Hi, hello everyone. Happy
Hi.
Friday. Good morning to everyone tuning in the United States. Good evening to everyone tuning in from India, from New Delhi, and good afternoon to our friends in Europe, and particularly to our friends in London who's tuning in right now from London. Hello. Um, Let me introduce our two guest speakers for this session of the LinkedIn Live. I'm very, very, very thrilled to have Malvika Raghavan here with us. Malvika, she's our senior fellow for India already for 2-3 years now. And she's been our most trusted advisor on how to track all of the digital policy developments in India. Hello, welcome.
Great to be here. Thank you for having me back.
Of course. And then I am equally thrilled to have the opportunity to introduce to our FPF community our new policy analyst who is based in New Delhi, Bilal Mohammed. Hello, Bilal. We're very happy to have you tuning in.
Thank you so much, Gabriela. It's a pleasure to be part of my first LinkedIn Live, and hopefully, given all the developments in India, may not be the last one as well.
I really like how that sounds. And I think you are onto something because it's just so much that is happening in the digital policy space, data protection space, data governance, AI governance space in India. And we want to be able to track most of that and to bring some light on the key developments. So the reason why we decided to have this chat today, it's because, of course, everybody knows the Digital Data Protection Act passed last August. And now we will enter soon the very special implementation stage. But more than that, there have been a number of other developments in this space, and we just want to bring an update to our community with what's happening on the ground. Let me start. We were discussing before going live that perhaps we should start with the latest news in the space, and the latest news relate to AI governance. So perhaps let me go to Bilal first. Bilal, if you can tell us what key development happened recently in the AI space, and then perhaps Malvika can give us her insights on that.
Sure. Thanks, Gabriela. I think to set some context, what's happening is that India is now actually going to go for general elections, I think, in sometime in May. And for those unaware, this is probably the largest democratic elections. I think 900 million voters are eligible to vote. And in the run-up to the election, the government is increasingly worried about how AI is impacting the sort of electoral process. And last week, the Ministry of Electronics issued an advisory to all platforms. And specifically, what it required was platforms seek explicit permission from the ministry when deploying any unreliable AI LLM models or LLM generative AI softwares to users specifically on the Indian internet. And for context, an advisory is not a legal instrument, but it is sort of a guidance given to users, so to say. And it also requires users to ensure that there is no bias or discrimination. Sorry, the platforms to ensure that there's no bias or discrimination, and it does not threaten the integrity of the electoral process. And any synthetically generated media should have some sort of identifiers. So that's the broader context, so to say.
Thank you so much for that. That's quite helpful to set the context. So, Malvika, how are you seeing this development, and what has been the approach towards AI regulation, AI governance in India? Does this signify a shift, or is it maybe just let's say the minimum necessary given the election context?
No, it's a really fascinating space as I've been watching it over the last couple of years. So the government had a few white papers and position papers on AI that they put out. And actually the positions specifically there, including, I think in Parliament, there was a member of Parliament who got up and said last year that, there is no intention to bring an AI Act. or any legislation, right? We are going to be the AI powerhouse and so on and so forth. So this is quite like a surprising to see the actual notification itself that came out from the ministry is quite surprising. I do think, so I think two things are happening here. On the one hand, we want to be kind of the AI powerhouse, and I think there's a lot of there's been a recent announcement of a new AI mission to be set up with like immense funding in India. I think this just today or yesterday. So there's a lot of that. But on the other hand, I think there's a sense that you need to, especially the big legal term here for, because I know FPF we like specifics in our community. I think it's around significant intermediaries, so significant social media intermediaries. So we're trying to make that distinction. Correct me if I'm wrong, Bilal, because you're kind of boots on the ground now. But I think the distinction that somewhere the political establishment is trying to maintain is between homegrown or startup AIs around the world and kind of these larger players who I think around the world there's this concern that there's election interference and so on. Yeah.
Yeah, wonderful to dispel a bit this development from last week, quite recent. Before moving to our next topics, let me ask everyone that's tuning in to drop questions or comments in the chat. We'll be happy to bring them into our conversation. So please do that. Right, let's go to the main dish. And the main dish here for the conversation will be breaking down what is going on with the DPDPA implementation stages. And in this sense, as we've seen in the law, a lot of the meat of the law was actually left for further implementing acts, for secondary legislation. And there's a ministry that's actually tasked, the government is tasked with adopting, implementing rules. And we know that the community has been really watching the space with perked ears for many months now to see where those rules will be published, when they will be published. Bilal, since you indeed have the boots on the ground, what is the latest that you are hearing about the timeline for these rules? And then perhaps you can also tell us what is known so far that the rules will cover, at least the first batch of these rules.
Sure. Thanks, Gabriela. I think so. As I already mentioned by you, Section 1(2) of the DPDP requires the central government to notify the date of sort of the act coming into force. So there are two ways to look at it. One is that it will be a phased implementation, which may mean that some of the platforms might be required to comply with it in different batches. So significant platforms may have a lesser period, and startups might have a longer period to comply. And the second issue is also that the rules will come as a set as per sort of announcement by the senior minister that it will come as a batch. And the initial timeline was supposed to be early Jan, and this has now, based on statements by the minister, been pushed post-elections. I think the concern was that with the elections around, we might not have sufficient time to ensure proper consultation. So the tentative indicated date is somewhere post-elections. Now, what that could mean is that with the new government in sort of power, we might see sort of new ideas coming into place. So there is a lot of scope in terms of what can be done in terms of how the rules will look like. But at the same time, when you're talking about provisions, specifically issues around notice and consent, children's privacy, consent managers, breach notification, and the operation of DPB itself, which sort of forms the crux of the entire legislation, all that will be determined through the rules.
Thank you so much for that update, and thank you also for mentioning some of the key topics that will be covered by the implementing rules. I think this is the right spot to also plug our overview blog for this series of webinars that FPF and NASSCOM has organized throughout the past couple of months, where we did some deeper dives, particularly in issues related to consent in the DPDPA from some relevant angles. And speaking of consent, Malvika, I know that you have been tracking a bit this idea of a consent manager. and the role it plays in the DPDPA, and also how it might work together with similar structures that exist in the financial space, which is a space that you have a lot of experience in. Can you share a bit about consent managers? What are their role in the DPDPA? And perhaps what would be most interesting to hear from you is anything you can share from the experience in the financial world in India with something similar to consent managers, and how that can inform the DPDPA structure.
Yeah, sure. I'll try and do, a very quick 2 minutes on it. And of course, what's interesting, I think, even in the webinar that we just plugged the link to, is it was very interesting to have someone join from Europe, where we're thinking about data intermediaries and so on and so forth, in the European, under the digital strategy in Europe and the Data Act and the Data Digital Services Act and so on. And in India, the story has been going on for a while. So at least, I think, close to more than 5 or 6 years now, we've had this idea of an account aggregator. So that's really where the story began for us. Interestingly, it kind of has a license from the central bank. They set up a new kind of license under a regime for non-bank financial companies that we have in India. And there's an argument whether they can be considered financial companies, because essentially what they are data sharing pipes. I think that's kind of an abstraction from the master directions that we have. What's interesting is that the idea of the account aggregator almost was cross-pollinated into the Data Protection Act. So I think it came later on in the drafts that we've seen in the legislation, but the final legislation has it. So it essentially, there is a definition for this entity on the 2G of the Act, and it says that it's any person who has to be registered with the board, so meaning the new regulator that will be set up. And they have to be a single point of contact to enable data principals to manage or withdraw their consent through interoperable platforms. So it's interesting because we don't have data portability anymore as a right. So that's kind of a nice trade-off in the Act. But it does seem that what this is aiming at is to kind of give again, this idea that there are certain significant entities that hold data. So giving an option to create a platform that's interoperable when it comes to data. I guess the last thing I'll say here is that it's obviously the big question is who will take this up? I mean, we have 1 billion plus people in the country. Many people still go on the internet on their feature phones. And, obviously the idea of the load that is required to manage consent dashboards. So I'm not personally a fan of consent, self-management. But I guess here we are again, long circle and back to consent management.
Yes, absolutely. And in fact, consent still plays such an outsized role, I would say, in the DPDPA. I was wondering, Bilal, what are you hearing on the ground? Are you seeing not controllers, companies, fiduciaries starting to think about their compliance strategies? Have you seen consent pop-ups recently when you tried to access services in India? How does that look on the ground?
It's quite an interesting question, actually, Gabriela. I think the fact that this conversation has been going on since 2017, with the act now being passed, it has definitely pushed the needle, I would say, in terms of making the conversations more active. And what I hear is that organizations are now closely looking at their data management practices, how the data flows take place within the organization. So they are speaking to stakeholders within the company to sort of understand, what are they doing with data, what are the current practices in terms of how they collect data. So that is being closely looked at. And something which is also being re-looked at is the relationship with data processors, in terms of what are the existing contracts, what are the clauses in the contracts. Because I think one significant departure from the GDPR, I would say, in the DPDP is that the onus almost entirely lies with the data fiduciary to see in terms of how they manage the data and how they control it. So they are probably trying to look at contractual measures to see, what is the liability in terms of how they deal with it. And I think in this regard, Asia Center, which is a think tank based in Delhi, they have done a survey of data fiduciaries. Although the sample size is quite small, there is some interesting insights in terms of how data fiduciaries feel about it. And just pulling out from the report, what I see is that 85% of the interviewed data fiduciaries, they have had preliminary deliberations on DPDPA compliance already, and 54% of them lack any kind of experience in terms of previously complying with data protection laws in other jurisdictions. So that's going to be the real challenge in terms of how they adapt to this. And one interesting insight is that majority of the respondents also noted that they would ideally require 24 months to comply with it, especially the verifiable parental consent requirements, because that's where I think there are questions about, what is the technology being deployed in terms of how you obtain verifiable parental consent. And I think FPF and Dialogue is a good plug here in terms of the work they have done. So FPF and Dialogue did a report recently on verifiably safe measures, which kind of looks at global best practices in terms of how technology companies can use measures to ensure that they are using safe measures when it comes to processing children's data.
Thank you for that overview. I'm not at all surprised to hear that there's kind of a frenzy going around with companies trying to break down the specific rules and prepare for compliance. Speaking of that, I want to go to the Data Protection Board, to Malvika in a second, but since you mentioned children privacy now, Bilal, I want to ask you to weigh in a bit on this topic, which correct me if I'm wrong, because I might be wrong. It's something new for the environment in India, this focus on children privacy, on even age verification, if we read that in the law. What are you hearing about this on the ground? And also, how do you think this came to be? Why do you think this focus on the rights of related to children's personal data came to be so central to the DPDPA?
I think one major reason is that it makes a major shift from other data protection laws in terms of the age for parental consent. So I think the definition says that any individual below the age of 18 requires parental consent. So that kind of makes the issue very broad, in the sense that there is no gradation happening. So any services for that matter will require parental consent. Although there are a couple of exemptions in the act, which will be determined based on the rules. It's unclear how it will actually shape up. But broadly, to restate the exemptions, it allows central government to sort of lower the age if it feels that there are verifiably safe measures being taken. And alternatively, it also allows central government to allow, for certain purposes, certain classes of data fiduciaries to track behavioral monitoring and allow better services. So the one major concern with this is that even services provided which will help sort of better services. For instance, when you talk about platforms which can be video platforms and also educational platforms, what happens is that because you're not allowed to track or monitor behavior, you're not able to provide the best content in that sense. You cannot personalize content for children below the age of 18. So that is a major challenge. And in terms of operationalizing parental consent, one major concern is that we are a mobile first generation in that sense. So it is not very easy to get parental consent when there's a single device in the entire family. So, how do you obtain verifiable parental consent in that scenario? And then there's a rural urban divide as well. So, these are all some of the challenges which industry is worried about. But I think there is plenty of scope for the rules to address this in some of the other way.
Thank you so much for giving us that context. Switching gears now and looking at the enforcement structure around the Act. One key task is the setting up of a data protection board. Malvika, what are you hearing about this? Are we going to see this board anytime soon? Perhaps before the elections? Is that like a crazy prediction, or more likely after? And how is that board being set up in the Act? let's say, independent, or is it under a government structure? What can you tell us about it?
So I think, I mean, again, this is, the great thing about making predictions is that anyone can make one. So my uninformed opinion, I think, as Bilal very rightly pointed out, I think there was this big sense based on a few ministerial statements that something is going to happen now. And if it really hasn't happened by March, I think it's a really it's a thorny time to try and set up a structure. So my sense is that I don't think this is going to happen before the elections. And this year already we're in election mode. I think there are two benefits to not doing it, right? I mean, one is that in any event, the government has kind of enforcement powers, as we are seeing, right, through some of these directions and notifications. They at least have a direct line with industry under the existing. So, setting up a new body, what is it going to add in terms of immediate reaction? The other thing is that the new body that's envisioned under the Data Protection Act is not really a regulator. It's not really a full-scale independent regulator like how you would imagine under, say, a GDPR-style regime. It's specifically an adjudicatory and enforcement body. So a lot of the regulatory powers and what you would need to start doing enforcement, because now we have like that, 20,000 feet, we have the principles, we have the act. The act has over 20-25 things that must be prescribed by rules, which government will make. So I think this body, for it to have something to do, probably we need to have it at the same time, at least at the very least, as some of these rules that hopefully we'll start seeing after the election.
Yeah, Bilal.
Sorry, just to add on to that, Gabriel, as well. I think one major departure which it makes is that it does not have the powers to take suo motu decisions. So it has to act on the basis of a complaint. I think this is not how we see typically in FTC, for instance, where FTC can take its own cognizance of issues and then drive it. Here it entirely acts on the basis of complaints. And another, I think, major issue is also that there is no option for compensation. So how do you incentivize data principals to raise their grievance? And then there's also penalties imposed on data principals, which is your data subjects under the GDPR. So yeah, those are the three sort of additions I had to make in this.
Yes, indeed, that was one interesting innovation to see. Even though I think we might have seen something similar in one of the other laws in APAC. But still, this idea of sanctioning the data subject is quite interesting. Let me just call it that. Malvika?
No, I was just going to, thanks for bringing that up, actually, Bilal, because I think one of the things is if you have an enforcement body, what are the causes of action? What actually kicks off a complaint? And the list there is very interesting, right? So a lot of it is putting this burden on the data principal to make a complaint. But literally, also, you can get intimation of a breach from a consent manager to inquire into the breach and get a penalty, which is another, I think, area that people are now concerned, because a breach notification is one way to raise the attention. And then the other thing is a reference made by the central government, right, under intermediary related rules. So it's got a very interesting funnel for this enforcement body to kick off. And I would think, if I was, kind of advising a company or working general counsel somewhere, I think that would be the concern. Like, how do you risk mitigate and how do I think about where these complaints could come from? Especially, I think, on the breach notification one, it's a bit hazy. I don't know, again, Bilal, if you've heard more about how people are thinking about that lately, but I think that's a major area of concern.
I think specifically on the topic of breach notification, it's the definition of it. So it also, if you look at the definition, it says unauthorized loss of access. So that could be anything. A power outage could be a loss of access. So does a data fiduciary now have to intimate data principals if there's a sort of loss of access? So I think those are the questions. I mean, fortunately, there's scope for the rules to clarify this. I think these are questions probably industry is thinking about, how do we address this? And also in terms of intimation, do you intimate the data principal at every instance, or is it just a line first with the data protection board and then subsequently to the data principal?
Thank you for that. And as we enter the last stretch of the session, I want to drive our attention a bit to another area that we've been kind of keeping an eye on, and that's the Digital India Bill and what's happening with all of that. And Malvika, I will first go to you because you have helped us in the past for FPF breaking down the IT guidelines. I'm wondering whether you have been looking at the Digital India Bill and that whole conversation. Can you tell the audience what is it supposed to address? And anything else you can share about that whole process?
Yeah, I think again, this is something I probably about 12 to 18 months ago, the conversation really kicked off about how do we interpret the Data Protection Act, right? So if you start with privacy and data protection, I think the broader framework, if there's one thing that because we don't have a lot of detail, we've started having a consultation around the Digital India Act. But I think what it's going to do is it's going to be a large data governance framework that's going to replace our current Information Technology Act, which was passed in 2000. And a lot of the current, the directives we talked about, the AI directive and other things, all of them come from the IT Act. So this is going to be a big one. I think there were consultations that were held around March last year, so nearly a year actually, that to talk about the potential for this legislation to come out. Initially, I think there was an idea that again it could happen in 2022, 2023, 24. Again, my sense is now it's not going to come out before, or we're not going to progress very much before the elections. But there is some form of so the ministry itself has put out a kind of document around the proposals and what happened in the consultations. Again, I don't want to say too much here because I think unless you start seeing text, you don't want to start like disinformation. We have enough out there in the online sphere, but that's the broad framework. Again, I just want to defer to Bilal because he's on the ground. I don't know if you've heard anything more recently since that.
No, Malik, I think you've touched all the points I wanted to speak about. A couple of other things that I see happening is that because the broad nature of things which are being regulated under this legislation, what we potentially could see a lot of challenges is in terms of regulatory overlaps, in terms of its interaction with other ministries, because based on the minister's statements, the broad areas of the principles it follows is on openness, safety, trust, and accountability. And openness, for instance, could have regulatory overlaps with the Competition Commission of India, which looks at digital competition and everything to do with competition. Similarly, consumer affairs is something which will. So, how does the ministry navigate these challenges in terms of carving out its specific domain within tech regulation? That will be an interesting question to see. And specifically on regulated design, also capacity. How do you ensure enforcement of such a massive legislation, so to say? And the fact that the government has now moved away from a regulator model to an adjudicatory mechanism. If we see something being replicated within DIA, how will it issue guidances is something which needs to be seen. How will the ministry look at both data protection as an issue and the entire remit within Digital India Act? So there's a lot of questions on how technically feasible it will be in terms of managing the sort of capacity.
This absolutely reminds me of a lot of complicated thoughts I have about what's happening in the EU with the GDPR, the DSA, the DMA, the Data Act, and some of the provisions in there. So absolutely fascinating to follow what will happen in this space as well. Now, just closing thoughts from the two of you, and I'll go to Malvika first. What do you think is the most exciting topic to track right now in the space? What are you most curious about to see that will happen in the next 12 months, let's say, in India, in the digital policy space, data space?
So I'm going to try and not be obscure because I'm an academic now. But what I think is really interesting is we talk a lot about statutes, but I think actually what we see in the digital space in India is a rise of like executive legislation, if I can call it that. So rules, directions, because we have power under the Indian Constitution for the executive to give directions to other entities. These may not like be enforceable for individuals and courts, but what we started with, the AI, the directives that you can give, you don't really need a statutory basis for the government to make constitutionally sound regulation. So my bet is going to be that the statutes are they're great marketing, right? We have a Digital India Act or AI Act, we have all the friends. But I actually think what I'm going to be watching is the rise of like executive rules and regulation over the next year, because I think somewhere it also meets this kind of thing that we've had in India, that technology and law doesn't keep up. And now I think we're seeing the consequences when the law does keep up a bit too quickly. So I'm going to be watching. But over to you, Bilal.
I'm just actually going to narrow down exactly onto what Malavika just spoke about. I think specifically what I am curious in the next year or so is how the Data Protection Board itself functions, because I think that will sort of guide us a lot in terms of how enforcement will look like, both in terms of DPDP and Digital India Act, because it will set the pace in terms of how the DPP handles complaints, and what is the mechanism in terms of its interaction with the larger ecosystem itself.
Thank you so much for those closing thoughts and setting us on the good track on what to follow in the next 12 months. As for myself, I'm just grateful to be working with the two of you, and because this gives so much insight and helps us to really understand what is happening on the ground. So thank you so much, Bilal, and thank you so much, Malvika, and happy Friday to the two of you. And see you soon. Thank you all
Thank you so
who's
much.
watching.
Yeah, thank you. Likewise. Happy Friday. Bye.